Welcome everyone to our extra special bonus call today. This was unplanned until I got to know Ian and really hear more about what he's all about. And so I thought it'd be really great for him to come and join us today because he is all about protecting coaches and keeping them safe and compliant with the laws that are out there, some of which we don't even know are out there that we might be breaking without even knowing it. So welcome, Ian Foster.
Hi, thanks very much, Anne, for having me. It's great to be on, and I really appreciate the opportunity to be of service to you and your tribe and your folks here. I love what I do, and I get excited about it, but I'm a law geek, so it's easy for me to say, but I will try to break things down, make it easy to understand. I'm going to go ahead and start sharing my screen here.
Okay, great.
All right, so can everyone see the PowerPoint here?
Yes.
Okay. All right, so we're just going to talk about learning to protect yourself and your business. This is the law made simple for retreat leaders. And one of the main things that I want to impress upon all of you from the beginning is that the law is not scary, or at least it doesn't have to be scary. If you have potential legal problems and you want to implement proactive solutions to help make sure you're protective, it just requires a few basic skills. So if you have common sense, if you're good at observing things, you're a good communicator, if you're good with details, and most of all, if you have a can-do attitude, those are really all the skills you need to understand the law and legal protection issues and make sure that you are compliant and safe. And if you are running retreats and live events, then I know you already have these skills. So it should not be a problem at all. If these are skills you already have, then we can put them to good work today. And so I don't want you to feel scared or intimidated. Of course, it does not hurt to have legal training and experience, but with the right expert guidance, anybody can do this. And you already listen to experts. So you listen to your experts when it comes to your technology issues, your marketing strategies, and some of your business planning and strategy issues. So there's no reason for the law to be any more intimidating than any of those subjects. There are always ways to get educated, like modules like this, and there are always experts to help out. So if you can get educated and if you can find the right people to help, then there's no reason to be intimidated or worried about what you're going to find in the law. Just a little bit about who am I. Anne introduced me. My name's Ian Foster. I got my law degree from UC Davis in 2001. I'm a licensed attorney in the state of California. My wife Heather and I founded our company Personal Empowerment Services. And we basically help people live their dream lives in several aspects. But one of the main things we're focusing on right now is specializing in helping coaches, therapists, and retreat leaders and healers get the protection they deserve for their businesses. You guys have poured your time, your energy, your heart, sometimes literally your sweat and tears into these businesses. And you deserve to have them protected. We have 40 years combined experience in the legal therapy and coaching professions, so we think that we're uniquely positioned to recognize the unique legal issues that you guys face and help explain how you can stay compliant and protected and have a lot of confidence that you're going to be all right. We're going to start off too with a little legal disclaimer. We are, after all, talking about the law, so kind of think of this maybe as your first little lesson. This talk contains my own opinions based upon my own experiences. This does not represent Anne's opinions or the opinions of her business. This talk is not intended to be, and it is not, legal services or advice, and you should not see this talk as a substitute for legal services or advice. And by being on the call, this has not created an attorney-client relationship with me or with my company. So even though I am a lawyer, we are not considering this to be legal services, and I am not your attorney for purposes of this talk today. This is, we're seeing this as business coaching. If you need legal services, contact a licensed attorney, and depending on your location, I might be able to provide you with a free referral. So here's what you can expect out of the talk today. We're going to cover a few key things. The first thing, we're going to talk about how the law is really all about relationships, and relationships are governed by contracts. We're going to talk about the 3 broad categories of legal relationships that are involved when you're putting on retreats and live events. We're going to go over the legal documents that you need and what goes into them, and talk about a few other legal considerations. And there's going to be some bonuses for those of you who are able to stay until the end. There's going to be a link to free resources that can, a free resource that can boost your knowledge of important legal issues and help you understand how your business is currently set up and what your current legal protection is. And for those of you who really stay till the very end, there's a special double bonus to help you jumpstart the legal protection in your business so you can operate with confidence and peace of mind. So like I said, the law is really about relationships. And when we talk about legal problems and legal issues, these are really just euphemisms for other people. If you put on a retreat at your own house and you have no help and nobody shows up, and it's just you talking to yourself, then guess what? You have no legal problems. The legal problems are really just a euphemism for dealing with other people. And the 3 categories of relationships involved when you're putting on a retreat or a live event are the relationship between you and your clients or attendees, the relationship between you and your partners and content providers, and the relationship between you and the retreat facilities where you're operating. Contracts are what govern relationships in the law. The law of contracts is really not that complicated. It's just about making sure that everyone understands their rights and obligations and lives up to them. There are some things contracts can do. They can define the scope and the nature of your relationship. They can create boundaries and limitations, and they can make sure everyone has certain rights and duties and obligations. And there are a few things contracts cannot do. Contracts cannot override the law or the Constitution or public policy or public safety. So you cannot have a contract that says that someone is required to discriminate based on based on race or gender or religion. You cannot have a contract that requires someone to commit some sort of illegal act like theft. So contracts, they can require people to do a lot of things, but the things that are required have to be otherwise legal. So we talked about the first category of relationships. That's you and your clients or attendees. And here's a few things you need to consider. So is everyone signing a contract or agreement? Everyone who's involved in your group program, your retreat? Do you go over the agreement with them personally? Do you give them the chance to ask questions? These are key things to keep in mind because you don't want your agreement challenged later on. I mean, yes, when someone signs on the dotted line, they are, signing on and obligating themselves legally to the contract, but there are lots of ways to challenge the validity of a contract. And if you can show that everyone signed something and that you went over the agreement with them personally, that you gave them the chance to ask questions, then it's much more likely that your contract is going to hold up in the end if there's any kind of legal dispute. Some things you want to keep in mind about the contracts you have with your clients and attendees. Where did you get the contractual language? So did you write it yourself? Did you have your attorney draft it? Is it done by someone who specializes in helping coaches and retreat leaders and live event leaders? Did you get it from a training program? What is it, a freebie off the internet? Was it boilerplate you found off of a legal website somewhere? So, think about where did you get the contractual language that you're using. Are you familiar with everything that's in the contract? Have you actually read it yourself and understood everything that's in it? So can you confidently answer questions? If your clients ask you questions about what this provision means or what that provision means, can you answer that question with confidence? Again, this all has to do with making sure that your contract will stand up in the end if there's any sort of dispute. And here's what you have to understand. If there's any ambiguity in your contract, it will be resolved against you. So the general legal rule is that the person who's creating or providing the contract, that's the person who's responsible for the language. So if there's a section in your contract that is not written well or is not easily understood, and you get involved in a legal dispute about that section, then the court or other body is going to resolve that dispute against you because you were the one who provided the contract. So that's why it's key to think about where did you get this language and how confident are you in it. So when we talk about what goes in your agreements with your clients and attendees, you need a description of your program. The clearer the better, and detail is your friend, but find a balance. Don't put anything in there that's not relevant. If it's relevant detail, you know, if there are clear duties and expectations, then put it in there, but don't put in extraneous detail that is not ultimately relevant. You need to talk about the limitation on the nature and the scope of your services. So, for example, are you a licensed professional? Are you a therapist, a doctor, a lawyer? Sometimes massage therapy needs a license, you know, psychologist. If not, or even if you are, but if you're not providing licensed services during your agreement, then your contract needs to be very clear on that. Your contract needs to spell out that this is not therapy, this is not psychology, this is not medicine, this is not law. Make it clear that this is just a coaching relationship and not falling within the scope of any licensed professional relationship. And here's where you have to understand local law. So generally, the law that applies if you're dealing with a client is the law of the place where your client is. So if you are in Florida and your client is in California, then the law that applies is California law because that's where your client is. And so if what you're doing is defined as therapy or psychology and they're in California, then you have to be aware of that. And this is where I use the phrase, you can't call a sheep a dog. Let's say you want to sell someone a sheep. That's great. You can sell somebody a sheep. And you can call that sheep a dog in your contract. You can have a contract that says, I'm selling you a dog, even though you're really selling them a sheep. And you can call it whatever you want in your contract. But ultimately, the law is still going to recognize that you're selling them a sheep. The law doesn't care if you're calling it a dog. So if the law where your client is defines your services as therapy, then what you are doing is therapy no matter what your contract says. Your contract can say up and down and front and back, this is not therapy. But if the service you're providing is defined as therapy under local law, then it is still therapy.
So Ian, I have a question already.
Yes, go ahead.
And that's great. That's great information. What about if your client, you live in Florida, your client is from California, but you're holding your retreat in Costa Rica? Does it still define the client, the laws from where the client is from, even though the services are being provided in Costa Rica?
Right. It's a great question, Ann. Thank you. And that's the next thing I was going to get to, is that if you're holding a live event, it's going to be the local laws where you're holding a live event that apply.
Got it. That's good to know.
So if the retreat is in Idaho, then you have to know how Idaho defines these services. If it's in Costa Rica, you may have to know how Costa Rica defines these services.
All right, cool. Thank you.
But often your retreat is often part of a larger package, you know, a larger group program where the retreat or the live event is just one aspect of it. In that case, you have to be aware of the law in the various places where your clients are. So I usually try to help people get compliant on the most strict rules of the strictest, you know, state or locality. and then in that case, you're probably compliant everywhere else.
Right, makes sense.
So a few more things. Your contract needs to go over your payment information. In the documents that I help people draft, I use the concept of your contract is the receipt itself. You can provide separate receipts for your clients via email or pieces of paper or however you want. But I usually draft the contract so that it contains a acknowledgement of receipt in there. And so when you give your client a copy of their contract, they also have their receipt for the payment. It needs to go over your full payment versus installment options, and your payment authorization language needs to be very clear. So I have seen contracts, coaching contracts, where it involves an installment payment plan, but the payment authorization was written poorly, and so it did not actually authorize the coach to charge the credit card again. It was just assumed that the coach would be able to charge the credit card again, but the agreement did not actually say that the coach would be allowed to. And so the client challenged that payment, and the coach was out of luck because the agreement did not actually authorize another charge on the credit card. Your program can be free. Often programs and retreats are free, or they're done for a refundable deposit. That can all be spelled out in the contract as well. If you have a group program or a retreat or event, you're often creating a lot of your own intellectual property. You may have worksheets, handouts, exercises, videos that you're supplying. That is all your intellectual property. And so understand the difference between copyright and trademark. A copyright is usually created by operation of law. So if you write a worksheet for your clients, that is your material. You don't necessarily have to go out and file something to have a copyright on that material. It belongs to you. So I usually just put the little copyright, with my business name on the bottom of all my material. A trademark is for a phrase, a marketing message, your business name, a piece of artwork, a symbol, a logo, that kind of stuff. And your trademark, you have to actually go file with the federal government to pay a filing fee. Put language in your contract to protect your work against theft of your intellectual property. You don't want your clients selling your work to other people. You don't want them claiming that it's their own work. You don't want them giving it away to people who might misuse it or profit off of it themselves. So you put language in your contract to protect yourself from that. And we're talking about deterrence here, not absolute protection. Ultimately, if you have a client who's going to take some of your intellectual property and go sell it off, you can't, there's not a lot you can do really to stop them. You're not sitting there next to them at their computer to hit the delete button when they're ready to hit send on the email. So you're just trying to deter people and let them know that you will protect yourself if you find out of any violations. And privacy and confidentiality are a big deal, especially in group programs and live events. You want to create a safe space for everyone. They need to be able to trust that they can relax, that they can trust you as the organizer, that they can trust their fellow attendees, not to abuse their privacy or release their personal or business information improperly. And so you want to spell out not just that you are going to protect your client's privacy. You also need to spell out that the clients are responsible for their own and each other's privacy. It should state in there that they are going to respect other attendees' privacy and not release other attendees' personal information without their permission. Make sure everyone understands their rights and obligations so that they all can trust one another. And there are legal limitations on privacy. There is no jurisdiction I know of where coaching is considered to be a legally protected or privileged relationship. So if you are subpoenaed and you're hit with you're served with a valid subpoena, then you have to answer that subpoena, even if it asks for your client's personal information. And I've dealt with some issues on this where coaches have sort of an absolute privacy protection in their contract. They don't make it clear that they will have to answer subpoenas or other legal requests. And then the coach down the road gets subpoenaed. They answer the subpoena. by revealing their client's personal information, because if they don't answer the subpoena, they're in contempt of court. And now the client sues the coach for violating their privacy protections because this was not all made clear up front. So the coach is now stuck between a rock and a hard place. Do they go to jail for contempt of court, or do they violate their client's privacy? You don't want to be stuck in that situation. There's really, once you're stuck there, there's no way out. You're in trouble on one side or the other. Of course, every contract needs something on liability waivers. And this language is really crucial. You need to understand the difference between liability waivers and indemnity. So a liability waiver is when your client essentially is saying they are not going to hold you responsible, or they're not going to hold you liable for any damage or losses that the client suffers during the course of your coaching with them. This is making sure that the client is responsible for their own actions and that you are not responsible for it. You don't want to be held liable if the client gets hurt, if the client makes a bad decision and suffers a loss, or even if they follow your advice and suffer some sort of loss. You want to make it clear in there that you are not going to be held liable or responsible for any damages or losses that your clients suffer. Indemnity is when the client protects you against liability to third parties. So let's say in following some of your advice, the client causes damage to some other third party, some stranger, and that stranger wants to come back and sue you, the coach, because the client was following your advice. So indemnity is when it says the client will protect you from that lawsuit and will pay any damages they cause to the third party. It's called indemnifying you against that damage. And that language has to be written precisely. There are several different ways to write it legally, but it does have to be carefully and precisely written. If it's not, you could find yourself in a lot of trouble. Spell out your cancellation and refund policy. Who can cancel and for what reasons? Are you going to make your refunds conditional or unconditional? So do you need the client to prove that they did some of the work and that they gave it a good faith shot? Or is it just an unconditional refund after 7 days or 30 days or whatever? And then have something on dispute resolution. So make sure you understand what arbitration is. Arbitration is when you get some sort of neutral mediator that does not involve the court system to look at things. And so do you want your clients to agree to go to arbitration before they go to court? And are you going to make that an optional part of your contract where they can just check it off and initial if they want that? Or are you going to make it mandatory where it's just a regular provision that they're signing off on like anything else? Here again, you may have to know what local law is. In some states, you cannot require people to sign an arbitration provision, and it will have to be optional. So if you have a client in state A, and state A says that you cannot make arbitration mandatory, then the contract for that client will have to have that provision be optional, and they can choose to check off on it or not. So this is something where you may have to have different versions of your contracts depending on where your clients are located. And then we get into some of the really boring but super important legal mumbo jumbo that goes into all of your contracts. This stuff can be kind of arcane and difficult to understand, and I get that this is a boring part, but it's also one of the most crucial parts to understand, because this is the legal boilerplate that can take down your whole contract and get you in a lot of trouble if you're not careful with it. So, choice of law. That means if you have a dispute about interpretation of the contract, which state's laws are going to govern. So you can put it in there. If you live in Florida and you want Florida law to govern any contract dispute, you can write that right into the contract, that Florida law will govern any contract dispute. Now, like I said, when it comes to the nature of the services you're providing to the client, it's still going to be the local law where the client is, or the law where you're doing the retreat. But you can have any state's law govern a dispute over the wording of the contract itself. Severability is another really important concept, and this talks about the ability to sever off one section from the rest of the contract. So if you're involved in a dispute down the road and a court says that Section 3 of your contract is invalid for whatever reason, it could be because it violates local law or public policy, or it's not well written. So a court says Section 3 of your contract is not well written. You do not want the rest of the contract thrown out. So you need some carefully written language in there that says that Section 3 is severable, so it can be severed off. So if Section 3 dies, the rest of the contract survives. You want to make sure that anytime any part of your contract is declared invalid, the rest of the contract survives. You need to have something that talks about how amendments and changes are made to your contract. So generally, in the United States and other common law countries, verbal contracts are just as binding as written contracts. If you have a handshake verbal agreement with someone, or an agreement you made over email, telephone, whatever, that is a binding contract, and there can be evidence of that by testifying to what you talked about, or showing the emails back and forth, or recording of your conversation. But any agreement you make with someone generally is binding, even if it's not written. But what you don't want to happen is for someone to come along and say, okay, I signed this contract with my coach, but then later on my coach and I had a discussion where the coach agreed to add on another module. And you don't remember that discussion, or maybe you remember it differently. And you need to make sure that those verbal additions don't become automatically binding on you. So you need some carefully written language in the contract that points out that any amendments have to be in writing, and that those verbal agreements are not binding unless they're written down and signed off by both parties. Something else I do in the contracts I write for folks is I have spaces for the clients to initial. You want the clients to initial next to key sections of your contract, or sometimes the bottom of every page. This makes sure that the client cannot later say that they did not read or understand some important section. And this, this legal mumbo jumbo stuff, this goes back to how much confidence do you have in the boilerplate that you're using. Did you get free boilerplate from somewhere? Do you understand what's in it? Do you understand how it operates? Are you confident you can explain it to your clients? If you get some of this boring boilerplate wrong, it can take down your entire contract and get you in a lot of trouble. So in addition to your group coaching contract, if you're having a retreat or live event, you need some sort of live event consent and release form, and this is going to be separate from your coaching agreement with them. This is the form that you sign when you go to retreats and live events yourself. Everybody always has you sign something that says that you understand that you're waiving your right to sue, that you might be recorded, that kind of stuff. So you need a well-written consent and release form. This, it needs to have liability waivers. It's language similar to your coaching contract, but there are some subtle differences to what needs to be in it because it's a live event. You need everyone's permission to do audio and video recordings and to use those recordings for future purposes. And again, it should talk about confidentiality and create a safe space where everyone can trust one another in there. So I get that this is a lot of really dense material. So everybody just take a deep breath. This is my little kitty, Cinderella. She's actually popped up here to say hello.
Hi, Cinderella. Cute.
She's the one making some of the noise in the background. So take a deep breath. It's okay. I get that this material it's a lot, but that's why you have people here to help.
No, it's great. It's been really good information. Thank you so much.
So are there I can take a few questions about anything we've talked about so far.
I know Christine had to jump off. She had another call at the half hour. And Bethany, if you have any questions, you can unmute yourself. And then I asked the one that came up. So
okay, very good. Very good. We will move on. So we talked about the big one, the relationship between you and your clients. These next ones we can go through a little quicker. So the next category of relationships that we need to talk about is that of you and your content providers or your JV partners and such. So here's some things to think about. Is your agreement written or verbal? Again, a verbal agreement with a content provider or a JV partner, can be binding. How are people compensated? Are you paying people to provide content and education at your event? Are they paying you a commission on what they sell, or is it some combination of both? It's important to understand who drafted the agreement because, like I said, ambiguities in the agreement are going to be resolved against whoever wrote it. So if you're the one writing the agreement and giving it to the other person to sign, you need to be really confident about what's in there and very clear on what's in there, because if ultimately anything is determined to be ambiguous, that will be resolved against you in any dispute later on. Some things to go in your agreement with your content providers: be as clear as possible on the duties and expectations. If you need to have definitions, then have those. You may have to define the name of the program. You may have to define the dates involved. There may be, if you're educating people in your program, you may have to define certain terms to make sure everybody's on the same page. Again, this does not have to be written, but it's usually better. It's going to definitely protect you better if it's written. And when you talk about cancellation and termination, this section is a little more important than it is in the one with your clients. I mean, if your client cancels your agreement and stops attending, well, then they stop attending, and that's pretty much it. But what happens if your content provider cancels the agreement on you? What if your retreat starts in 3 days and you were expecting that person to give a talk? What happens to that part of your retreat now? Is that person required under the contract to go in good faith and try and find someone else to replace them who can do similar content? Is there some sort of procedure or recourse? Or for their protection too, what happens if they've made their travel arrangements? They have plane tickets and hotels lined up and you cancel the retreat, or you tell them they're not welcome anymore. What is their recourse? This all needs to be spelled out in advance so that you're not just fighting over what happens later. And as far as payment goes, is everybody clear on how you're being paid? It's okay to put mathematical formulas in your contract, so if it's not just a flat dollar amount being paid from one party to the other, if it's a formula based on how many people attend, how many people purchase certain products or whatever, put that formula in there. There are plenty of business contracts nowadays that have mathematical formulas in them. Liability waivers. Again, you need to have language on liability and indemnity in your contract with your content provider or your JV partner. These are just as necessary. And look, I know you are absolutely certain that your partners are not going to sue you. Of course they're not going to sue you. If you thought they were going to sue you, you would not be partnering with them in the first place, right? Well, you're right. None of your content providers and none of your JV partners are ever going to sue you until one of them does. Our courts are clogged up with businesses suing each other nowadays. That is most of what our court system does, is handle lawsuits between businesses. And none of those businesses thought they were going to sue each other when they started working together. None of them thought, I'm going to work with that business across the street and partner up with them because I think he's going to sue me in the end. No, they all were on good terms when they started, and now they are all in the courts clogging it up. So you need this stuff in place. You need to be protected beforehand. You can't just wait until something, well, you can wait until something just happens. That's your choice if you want to play Russian roulette with your business. But you would never advise your clients to play Russian roulette with their business. So take your own advice. You need all of the same mumbo jumbo and legal boilerplate is just as important. And again, you need some dispute resolution procedure. In my contracts of this nature, I usually have it say that if there's a dispute, that the two parties will try to resolve it amicably first before moving on to any other thing. And then if that can't work, then they move on to arbitration. And then if that doesn't work, that lawsuits are a last resort. But that can all be spelled out in your contract with them. The third category of relationships is between you and the retreat facilities. So a few things to think about. Do they have a standard contract that they have everyone sign? Is it negotiable? Do you have an opportunity for your attorney to review it? So, and this is where I want to tell everyone that you need to stand in your power. You are a powerful person, and you have negotiating power, and you have wonderful things to offer the world here. You have great things to offer the retreat facilities. You are benefiting them as much as they are benefiting you. So if you can negotiate the contract, then negotiate it. If there's something in there you want to change, then ask them if they will change it. Don't be afraid to ask them. And you may have to give up something in return, and that's fine. That's how negotiation works. But at least then you are getting a more favorable term and something that works to your benefit. So take your power and don't be afraid to ask them to change the terms of their contract. These are, especially if you're at a big hotel chain where you're running your live event. These are huge companies who are used to just railroading people and running over them. You don't have to get run over. Use your power and talk to them about the terms. If you have an attorney and you want to get your attorney involved, do that. Especially if you have somebody on retainer, get your attorney to look at the contract first just to make sure you are not missing anything important. And make sure you understand the cancellation and termination provisions. If you have to put down a deposit, is it refundable? What happens if somebody cancels? I'm dealing with a client right now who put out a big deposit, several $1,000s to a really nice retreat facility, and then the retreat facility closed its doors and stopped operating. Now my clients and several others are trying to get the deposits back, and I'm not sure how easy it's going to be. We'll have to see, but a lot of it will depend on what's in the contract. I haven't looked at the contracts yet, but that's something to think about. So that is a real problem that happens.
That sucks. That's really rotten if that happens.
No, I can tell you no end of the horror stories and the heartbreak that I've seen happen, which is why I have such a passion for helping people out. I don't want to see that heartbreak happen anymore.
Absolutely.
So a few other things to consider. We're going to talk a little bit about insurance, about your business entity formation, and about whether you have the proper licenses in place. What kind of insurance do you have? Especially if you are running some sort of live event. I would not run a live event without insurance of some kind in place. Do you have, are you a licensed professional like a therapist or a doctor? So do you have professional liability insurance, malpractice insurance? And if so, does that cover your coaching activities and your live retreats? It may not. You have to look in there and be very clear about what it covers. If it doesn't, do you have to add something onto it? There is paraprofessional insurance out there for coaches and retreat leaders. Look into that. Do you have umbrella insurance? They call it that because it covers everything. Your umbrella insurance might be under your business. Sometimes you can get an umbrella insurance as a rider on your homeowner's policy. So look into that as an option. But again, whatever your insurance is, read the language of the terms very carefully and make sure it covers your retreats and live events. You don't want to find out later on that you had this umbrella insurance that you thought covered everything, and it turns out there was an exception for events that you held off-site. That would be a bad thing to find out when you're hit with a $100,000 lawsuit. Does the retreat facility have insurance? They almost certainly do, but what's in it? Ask them about their insurance. Does it cover you, and to what extent? These are all things you need to understand before your retreat starts. You don't want to start asking these questions after your retreat's over. It would be like asking your dentist about the importance of flossing as you're getting a root canal. It's too late. How is your business legally organized? Do you have a corporation? Do you understand the difference between C corporations and S corporations? That is mainly a tax issue, but it's an important issue. I was a tax attorney for the government for over a decade, so one of the things I do now is I advise coaches on the tax implications. I see coaches all the time now setting up the wrong business entity and getting themselves in trouble tax-wise and paying a lot more than they need to because they got some bad advice from someone who is not looking out for their best interest. It's a very common thing. Do you have a limited liability company, which is a hybrid entity that operates like a partnership in terms of for tax purposes, it passes the income through. So the limited liability company does not pay any taxes itself at the entity level, but it still gives you liability protection. Are you a sole proprietorship, which means you have no entity registered or set up at all? This is about protecting your personal assets. If your business liability is under the umbrella of your business entity, then that protects your your assets that are outside of the entity. So if you get sued, if you're operating a retreat and you have a business entity and you get sued or in some other sort of trouble, then it's the business entity that absorbs that liability. And, then it's more difficult for people to come after your house or your cars or your other personal assets. Are you compliant with license requirements? So again, are you a licensed therapist or psychologist, counselor, doctor, lawyer, CPA, any of those? Do you have the proper license? Are the services you're providing covered under that license? Do you have the proper business license? Are you registered to do business in the city or the state or the county where you're running the retreat? There may be local rules that say if you're coming to this city to run a live event, you need to be registered to do business in that city. So look that up before you go there. You don't want the city's tax man knocking on your door after you've run the retreat saying, hey, where's your license? And then you're not just having to pay the license, you're now paying the penalties and interest on top of it. So understand that before you operate. Do you have your, wherever you're operating your business, wherever your home base is, do you have the proper business license to operate there? There are all kinds of government licenses to understand and be aware of. And again, these are things that you don't want to find out about, when it's too late to do something about it. So, like I said, this is some dense material. There's a lot in there. It can be a little bit intimidating, but it really is okay to ask for help. If you're asking people for help on your IT issues and your marketing issues, then it's okay to ask for help when it comes to these kind of legal and business issues too. So we offer a few resources to help you guys out. First is our free online legal assessment for retreat and live event leaders. We also have a group program coming up that has a discounted pilot price. And then we also can give you instant access to the key legal documents that you need to run your retreats and live events. And then if you stick around, again, there's a special double bonus at the end. Where to find help? Our website is personalempowermentservices.com. Again, that's personalempowermentservices.com. Click on the Retreat Leaders tab. So this is what you see when you go to our website. You go to personalempowermentservices.com. You'll see the Retreat Leaders tab right there. You click on that tab, and up comes our Retreat Leaders page, and it tells you what you're going to find on the page. And so the first thing you'll find there is our free legal assessment. This is a free resource that we have for you. It asks you important questions. It gets you thinking about the legal issues. It gets you thinking about how those issues apply to your business and impact your business, and what sort of things you need to improve or implement to improve your legal protection. It has built-in logic so that depending on how you answer some questions up front, it changes the questions you get later on. That way it makes sure that all the questions are relevant to you and your specific situation. And this assessment is geared specifically towards retreat and live event leaders. It should take you less than 10 minutes to complete. And in that 10 minutes, you get a lot of education, you get information, and you get to understand, you get a score at the end that tells you what your level of protection is, and you can stack up your score against the top score to see how well you're doing, and it kind of categorizes you as to how well you've protected yourself so far and what you still need to do. So, and something you need to understand when you're answering these questions in here, we do not use your answers to those questions to, we do not sell those answers to anybody. We don't collect those and use them to market to you or anything. We do collect your email address at the end of the assessment. But as far as your answers to the questions about how you're operating your business, those answers are not used to market to you and are not used, they're not sold to anybody else. That stuff is all kept confidential. So if you want to take our assessment, you go to personalempowermentservices.com. On the Retreat Leaders tab, you just scroll down a little ways. You'll find our free assessment is embedded right there in the page. You just click on Start the Assessment Now, and 10 minutes later, you get scored and you'll have a much better idea where you stand. We offer that free to you just to try and reach and help as many people as possible and get people started on getting protected. We also have a group program coming up. We've called it Legal Protection for Coaches Made Easy. This is for coaches who run individual programs, group programs, and live events, you know, coaches and healers of all kinds. It's a 5-week group program. There's going to be 5 video learning modules that discuss the key principles of protecting your business. You're going to learn all the essentials about how to protect yourself from potential legal challenges. There are 5 live question and answer calls on Zoom. I will be on there answering your questions live and helping keep you accountable, keep you on track with actually implementing what you're learning, so that you're not just absorbing information but actually making things happen. And along those lines, there are going to be slides, worksheets, and exercises. We want the material really to sink in and to get you actively implementing the principles in your business right away. There will be a 6th bonus module. We have worked with a lot of coaches who are also licensed as therapists or psychologists, doctors. Some coaches are also lawyers or chiropractors or licensed massage therapists. And when you are a coach who is also licensed in any of those professions, you have unique legal challenges that face you. There are certain advantages to having those licenses, but there can be disadvantages as well, and you need to make sure that your license is not put at risk by your coaching business. And that's easier to do than you might think. So we have a special 6th bonus module, you know, with a 6th module of video content and a 6th live Q&A call that will go over all of that. There will be an exclusive Facebook group for those who are enrolled in this program so that you can get your questions answered on a daily basis. The material will come out at the beginning of the week, and then you have all week to complete the material and to ask questions on Facebook. I will be checking it every day to make sure that everyone's getting their questions answered, and that they're, you know, if they need any help making progress, we can make sure everyone's making the progress they need to make. Mark your calendars. The program begins in 2 weeks. So the first video content and worksheets will be released on Monday, April 29th. And then you have all week to work on them. So the additional modules will be released each Monday morning after that. Our first live Q&A call is Wednesday, May 1st. And then each live Q&A call will be held on Wednesdays, every Wednesday at 10 a.m. Pacific or 1 p.m. Eastern time. Each week after that. So you have a couple days before the call to look at the content and to think of any questions you might have that we can help you out with. So I've been an attorney for nearly 2 decades. I have some very deep specialties and experience in businesses, in taxes, and in specifically the last few years, I specialized in helping coaches and live event leaders. There are very few attorneys out there who specialize in that, and so a few of us are kind of pioneering a new specialty in what is still a young industry. So I charge $500 an hour for my services. In terms of the hourly rates for my legal instruction and advice, this program is at least a $10,000 value for all the hours you're going to get from me out of it. But like I said, I've seen the heartbreak of what happens. It only takes a tiny unintentional mistake to take down your business. And I will be giving you some of the examples of what I've seen in the group program. But like one of them is the coach who didn't make it clear that if he got a subpoena, he would have to reveal personal information. That little mistake has cost him his coaching business. I know another coach who is also a therapist who made a tiny record-keeping mistake, and now he's lost his therapy practice and his coaching practice.
Oof.
It's just, it's heartbreaking to see what happens. There are endless examples and endless ways to get yourself in trouble with a tiny mistake, and these are not nefarious mistakes. These are amazing people with amazing talents and gifts who were doing good in the world and serving their clients, and now they can't do that good anymore because of a small mistake. I just don't want to see that happen anymore. So I'm trying to reach as many people as possible. I've been doing, some programs and some one-on-one work, but I want to make this program as accessible as possible to everyone. So ultimately, I'm going to be offering this program for $14.97, which is 85% off of what you would pay for my hourly rates for the same sort of attention. But this is the first time I'm running this specific program. I'm looking for feedback to help improve the program, and I just want to reach as many people as possible with this first run. So I'm offering a pilot price discount of $147. That's an additional 90% off what the ultimate price will be. Again, my passion is just making sure as many people as possible get the help they need. So I'm offering this discount to give people an incentive to get involved.
That's
now,
awesome.
I'm a huge fan of Ann. Ann and I we've really connected well, and I'm a huge believer in what Ann's doing, and I'm a huge believer in you guys as Ann's customers, and so I want to give you guys an extra incentive to get the help you need. So in order to support you guys and give you a jump start, I want to give you an additional 33% off the pilot program price. So if you use the coupon code DOLPHIN33 on the checkout page, you'll get that extra third off, and your investment in the program is only $98.49.
Wow, that's incredible. What a deal. And I know that what you've been presenting today is a bit overwhelming, and there's a lot to consider. And it only makes sense that we jump into your offer so that you can walk us through it and help us implement what you've been teaching.
No, exactly. And it's going to go through all this in detail. It'll go through it, obviously a little bit slower than I did today. So you won't have to frantically take down notes. It won't be overwhelming. There's going to be worksheets, exercises, the live Q&A calls to actually help you understand. We're going to hold your hand and walk you through it the whole way. So this coupon is good for the next 48 hours only. And I've done that. I know we all know the marketing gimmicks of creating pressure and make it time sensitive to make people act. But I'm doing this because I want you to get the help that you need and, quite frankly, the protection that you deserve in your business. I want you to have confidence in your legal protection. And I know how this works. We will get off the phone call. We will get off the recording. We will get busy. We have to feed the animals. We have to clean the house. We have to get to work on our next business thing. We have to send out our emails. And the next thing you know, time's gone by and you've not signed up. And then you're not getting the help that you deserve. I want you to get the help that you deserve. So this coupon is good for the next 48 hours only. After that, the price goes back up to $147, which I still think is an amazing deal. But I want you guys to get the extra discount. So please sign up in the next 48 hours. We do have something else for you. Let me show you how to do that real quick. So again, if you go to our website, I want to make it easy for you, personalempowermentservices.com. Click on the Retreat Leaders tab. So if you scroll down, you'll see the section for legal protection for Coaches Made Easy. This is our group program. You'll see the button right there, sign up for the pilot price discount. That will take you straight to the checkout page. Don't forget to enter your coupon code DOLPHIN33 to get your extra amount off. And you can sign up right away, and then we'll get you enrolled, and we'll send you emails with all the details on how to participate and get all the content out of the program. Now, as you've seen today, there's a lot of content to learn, and that's why we have that program to help you learn. But what you're going to learn in the program too is there also is some work to do, unfortunately. If you want to get your protection set up It's more than just learning what you need. You have to actually do it. If you don't go implement what you learn, it doesn't matter. I can teach you everything about what needs to go in your proper legal documents, but if you don't get those legal documents in place, then you've learned it for nothing. So why not put my experience and my expertise to good use? I've been doing this for decades. I can do the work for you. I have a package of 4 key legal documents that are made especially for retreat and live event leaders who run group programs in their live events. I have carefully crafted these to give you the confidence in your legal protection. The documents I've put together already take account of everything I've talked about today and everything I'm going to talk about in the program. All of the legal mumbo jumbo, all of the boring boilerplate, the liability language, everything we talked about today is already in those documents for you. And it's already been drafted by someone who's an expert in how to do this and how to help people in your position. So you're getting confidence that it was drafted by someone who knows what they're doing. This is a lot different than the freebie stuff you're going to get off the internet. I've looked over a lot of group coaching contracts and live event contracts that I've seen that come free with some training programs, and some from some coach certifications, or that you can get free off the internet. The freebies out that I've seen are very lacking. A lot of them don't even look like they were drafted by a lawyer. The ones that were certainly were not drafted by someone who specializes in helping coaches and retreat leaders. I would not use those contracts for myself. I don't trust those freebies out there to protect me, and so I wouldn't trust them to protect you. So this way you're getting confidence that the documents are put together properly, and not just by an expert, but by someone who's in the coaching industry with you, by someone who actually cares about what you are doing. That the confidence that the documents are put together by someone who understands coaches and who loves the industry and who loves coaches and who really wants to see you succeed. So these are trying to put you in the best position possible. You get peace of mind knowing that you are as protected as you can be, and you can relax and use your amazing God-given talents and gifts to go out there and make the world a better place, because that is, after all, the whole point. That's what you're doing with your business as a heart-centered entrepreneur. You're serving your clients, you're making their lives better, you're trying to change the world. I want you to have that confidence and be able to relax and do that without having to worry about the legal side. Let me worry about that for you. Here's what's included. You get a group coaching agreement. This is a detailed coaching contract. You have to do just a little minimal customizing in it to make it fit any group coaching program that or package that you're offering to your clients, but it has all of the appropriate language already included in it. You get a content provider agreement. This is a thorough thing, again, with some minor customization, like adding in the payment formulas. You can make it fit any agreement with any of your content providers or your JV partners. This way you have a written agreement with your partners and content providers, and you're not just relying on everybody's recollection of your verbal conversation that you had 3 months ago, over drinks over dinner. This way everybody is very clear on what their duties are and how everybody's getting paid, so you don't have disputes in the end. You get a consent and release form. This is that form that you hand out to your clients at the start of your retreat or live event. All you do is fill in a couple blanks with your name, you print it out, and then you have your attendees sign it as soon as they show up to the live event. And finally, a marketing release form for your clients. You cannot use your clients' information or their testimonial to market to new clients or for future education without their permission. And personally, I do not rely on my clients' verbal permission. I do not even just rely on email permission. Whenever I use my clients' information to market, I have them sign a marketing release so that I know that I'm protected, so that they can never come back and claim that they did not give permission for this. So I want to make a special promise for you guys and clients. Something you need to know: lawyers generally are not allowed to make promises. It's against the law for me to guarantee any result for you or any outcome. I cannot guarantee that you won't get sued. I cannot guarantee that if you do get sued that you'll win. I'm just not allowed to make that sort of guarantee, and it would be irresponsible anyway because everyone's situation is completely different. And I cannot foresee in the future what might happen to every single person who uses these documents. But here's what I can do. If you get involved in a legal dispute that involves one of the documents that you purchased from me, I will apply the amount you paid toward a legal consultation at my hourly rates. So you will get some free legal help out of it. If you get sued and that lawsuit involves your group coaching agreement you bought from me, then you get a legal consult, and you get to use the amount you paid for the agreement to, you get to apply that towards my legal consult at my hourly rates. So here's the value included in everything. In terms of my hourly rates, it would cost me about 10 hours to create these documents for you if you were just to come up to my office. And so we're looking at about a $5,000 value in terms of my hourly rates. Again, though, like I said, one little legal mistake, completely unintentional, can ruin your business. And it's heartbreaking for me to see that happen. I don't want to see it happen anymore. I love the coaching industry, and I want to see the industry flourish, and I want to see all of you flourish. So I'm trying to reach as many people as possible and make this stuff accessible. So for a limited time, I'm offering this package for only $497, which is less than 10% of what you would pay, what the general public pays when they come to my office and pay my hourly rates. So you're getting a 90% discount on these documents. If you've ever worked with a lawyer before and have them drafted documents for you, you understand that at $497, that's a massive discount over which you generally pay lawyers for this kind of work. But again, I'm trying to really help out Ann and her customers. I'm a huge believer in what Ann's doing, and I'm a huge believer in what you guys are trying to do. So I'm going to give you that 33% off again to try and make this accessible and get you the protection you deserve. The coupon code Dolphin33 still works on the checkout page for these legal documents. So that brings your investment in the documents down to $332.99. That's all you pay for these 4 documents drafted by an expert. You get confidence, you get peace of mind, and they are pretty much ready to go out of the box. You just fill in a few blanks, add in a few details, you print them out, and off you go. You can get these documents literally working for you today in your business. So again, the coupon code is good for only the next 48 hours, and then the price goes back up to the regular $497. This is because I want you guys to get what you deserve. You deserve the protection, you deserve that confidence, so I want you to act on it and get the value that I know you all deserve out there. So, like I said, for those of you who stick it out to the end, there would be a special double bonus for sticking it out. I really, really want to help you guys out and support Ann and her customers, so here's your special double bonus. If you purchase the document package in the next 24 hours, using your Dolphin 33 discount, so you have 24 hours, if you go buy the document package, I will enroll you in our group program for free. So you get the document package and the group program for the one discounted price. That's good for the next 24 hours. So you get the document package, which is $5,000 worth of my time. You get the group program, which is 10 grand worth of my time if I were to give you that advice at just my hourly rates. You get free legal advice if you get into a dispute, which is a $500 value. So you're looking over $10,000 in value. Oops, I got my typo there. It should be over $15,000 in value. I'll have to fix that for the next presentation. But your investment is only $332.99. So to purchase this, it's very simple. You go to our website, personalempowermentservices.com, click on the Retreat Leaders tab, scroll down to the section on expertly crafted legal documents, and you'll see the button there for I'm ready for instant access. Click on that button, takes you to the checkout page. Don't forget your coupon code, Dolphin33, and you get everything for $332.99. So remember, personalempowermentservices.com, click on the Retreat Leaders tab, use your coupon code Dolphin33 at checkout, The coupon code is good for 48 hours. But right now, if you purchase the document package, you will get access to the group program included for free. And that special is good for the next 24 hours only. Again, because I know we all get busy, I want to give you incentive to act on this so that you can get the maximum value out of it that you deserve. And mark your calendars. The group program begins April 29th. That's a Monday with the first live call 2 weeks from today on Wednesday, May 1st. I'm very excited to run. Like I said, this is the first time I've run this particular program. I'm really excited to reach as many people as possible with it. I actually think it's going to be fun and interesting. Hopefully I can make it fun and interesting for all of you as well. So, does anyone have any questions I can answer?
Wow, Ian, that was really great information. So much to think about and really great offers. And I highly recommend that you guys check that out and take advantage of those offers, because I mean, just those legal documents, just to have those ready, prepared to just plug in your particulars would be really life-saving, I'm sure.
Thanks very much, Ann. I appreciate it. No, like I said, I'm a huge believer in what you are doing. I mean, I love the retreats that you've put on. I've been on some of your whale watching trips. It's amazing fun. I love how you're helping people, and I just want to make sure that your clients really get what they deserve, they need. You know, it's not just that they need legal protection, but they deserve the protection and the peace of mind, and knowing that one tiny misstep is not going to just take down their whole business.
Yeah, it's a little scary to think about, and I know that it makes it really easy to not do anything, to get, you know, kind of paralyzed in that. And I'm the classic head ostrich and the head in the sand kind of, oh, it'll be fine, it'll be fine. But, and thank God, knock on wood, nothing has ever happened that could ruin my business, but I can see how it would. I mean, I recently had an experience with a co-leader on a retreat where we didn't have a partnership agreement. And at the end, she decided she should get more money than was agreed upon. Now, thankfully, she hasn't sued. You know, in the end, we were able to work it out.
Right.
But it could have gone that route easily if she had decided to take it that far. So, yeah, it's just nice to be able to have the partnership agreement, the client agreement, and know how to read and deal with retreat facilities, hotels, etc. So this is really great. Thank you so much.
My pleasure. Absolutely.
All right. And Bethany, if you have any questions, feel free to mute yourself and unmute yourself. But yeah, I don't have any questions. I think this was really, really thorough, really valuable, great information. So again, thank you, Ian, for taking the time and putting this presentation together for us. And I know everybody in the group will really appreciate the value you've given us today.
Great. Thank you so much, Ann.
You bet. And those of you watching this recording, and for you live on the call, this is our very last gathering for the Retreat Leaders Program. And it's been such a pleasure, such an honor to support you. And I'm here for you. If you need any additional support, just reach out to me by email. I'll be in the Facebook group. And I'd love to meet with each of you personally on a call, just to kind of follow up and see how the course went for you. So thank you all, and best of luck on all of your retreats. All right. Thank you, everybody. Bye-bye.
Bye.